So two quick questions today, Bruno. And the first one I'm going to ask you, and it's just a touch base. So we've done this question before, but it bears reminding every couple of months. And it's just a question to go through in general. What does an eviction look like within the South African context?
So an eviction could be a very, very daunting experience, and it's important to understand the different levels that the eviction process goes through so that you can prepare yourself, especially if you have to undertake an eviction. Now, the first step is normally to give notice to the occupier. So if you speak about evictions within the leasing landscape, there would be a tenant on the property, potentially hasn't paid the rental that's due, and you'd want to give notice and inform them of the breach of the lease agreement and that you intend to cancel the lease agreement within 20 business days, usually, affording them an opportunity to pay any arrears that might be due. So that's usually the first step. We call it phase one in practice. So if you approach an attorney like myself and we speak about phase one, this is normally when you send out notices that are, yes, of a legal nature, but not necessarily part of the court process. As part of phase one, if the tenant or occupier fails to vacate, fails to pay the arrears, a second notice is then sent cancelling the lease agreement and asking them to vacate the property, demanding them to vacate the property. Now, there's often some confusion where clients approach us and ask us to send out an eviction notice. Now, an eviction notice is not a court order that is ordered by the court forcing an occupier to vacate the property. The eviction notice normally is a letter, simply a letter, after the period has lapsed, that informs this occupier and this tenant that he's breached, that the lease is now cancelled, and that they have to vacate the property. Now, you find that there are quite a number of occupiers and tenants that vacate at this point in time. So when undertaking the eviction process, as it were, it doesn't necessarily mean that you need to undertake all 5 phases. Sometimes it ends on phase 1. And let's say, for example, that you'll find that 15 to 20% might end on phase 1 and people will vacate the property voluntarily, but this does not mean that you will necessarily be able to collect your money, but at least the tenant is no longer on the property. And this then takes us to phase 2. If the tenant remains on the property and refuses to vacate, you have to do something about it. Now, in our law in South Africa, there is no way to evict a tenant from a property unless you approach the court. And that is exactly what phase 2 does. It's approaching the court. Now, here an attorney usually would draft the application, would draft an affidavit that goes along with this application, and we would issue it at court and we would serve it on this tenant. What does this do? This notifies the tenant that you have instituted proceedings for their eviction from the property. The sheriff serves it, the tenant is now informed and has a certain period of time to oppose the application. Now, again, I have to pause here. What does this mean? Now, once you instituted the eviction application, now the tenant becomes aware of this. 70% of the time, a lot of tenants would vacate after receiving this application because simply it does not make financial sense to oppose an application at this point in time, especially if a tenant is paying rentals of 4,000, 8,000 Rand. They're not going to spend their money opposing an application, but again, this is not this, although we see it more commonly that people will vacate, there are tenants that will oppose. So please do not think that simply by serving the application, you will be able to secure the tenant vacating the property. Now, if the tenant does oppose, which sometimes happens, you have to go through the opposed motion process. And that is a standalone process, and you will require your attorney to advise you appropriately on that process. But assuming that the tenant does not oppose, but remains on the property, you have to continue with the process. So the next step, phase 3, is this. It's a bit of a strange process because it doesn't have, it doesn't, in any other process in our law, we often don't find these type of notices to be required. But in an eviction, you have to notify the tenant again that you intend to evict them, you have to notify them that you will be applying to court on a certain date, actually doing an appearance and asking a judge or a magistrate for an order for their eviction, and you have to inform them of that date. Now, this is an additional process because most of the time you simply serve a notice of setting down the matter, but here specifically you inform them of their rights. So it's very similar to the criminal process where when a person gets arrested, just to make sure they know their rights, they are informed of it upon the point of arrest. So this is a very similar process. It just advises people of their rights. Now, why this exists is because sometimes there are very complex evictions, like farm areas, for example, where advising each and every person of their rights might be particularly difficult. So one may find that there's a special way of giving out this notice. And this is why you have to go to court, request the court for a directive on how you're going to advise them again of their rights, and you're going to serve this notice on them in order to set it down for hearing. And that brings us to phase 4, which is the actual hearing of the application. It's when you approach a magistrate or a judge and you ask them for an order to be granted. Now, again, unfortunately, there have been times where this process is delayed by way of a postponement. So please do not assume that simply by reaching phase 4 with your attorney that the order will be granted, because it is upon this instance where sometimes the tenant does approach the court very last minute and suddenly they advise the court that there is opposition to the application. So just be warned that you have to follow out the whole process. There may be some delays if the tenant decides to oppose, but again, that's each case would have its own circumstances. And the last phase is phase 5. Now, presuming that the magistrate or the judge has granted the order, phase 5 is the execution of the order. It's when the sheriff goes out to the property and forcefully removes the tenant, places all his belongings outside of the property, and officially evicts this tenant. Now, again, under most circumstances, this is a simple process. Unfortunately, if you are undertaking an eviction of multiple tenants, dangerous tenants, tenants that might push back or might offer resistance, one may need the attorney to approach the SAPS to assist the sheriff or private security companies. But again, that is the exception, not necessarily the rule. One hopes that by the time an order is acquired, that the sheriff can simply attend the property, potentially use a locksmith to enter the property and forcibly remove the tenant and place them outside of the property. And that is the completion of phase 5.
Perfect. Thank you for that, Bruno.